This meeting of the Anderson Township Board of Zoning Appeals is hereby called to order. This board was established pursuant to Section 519.13 of the Ohio Revised Code by the Anderson Township trustees to provide administrative relief to any person or entity adversely affected by the Anderson Township zoning resolution. Will the secretary please call the roll?
Rick Oversmith.
Present.
Brian Ellis.
Here.
Jeannie Bechtold.
Here.
Steve Haver.
Here.
Brian Johnson.
Here.
Thank you for coming to this meeting. Please be aware that this meeting is audio and videotaped and may be carried live on cable television. First, I'll outline our procedures. A summary of the appeal is presented by the staff. Then the appellant will present its case. The board members may then ask questions of the appellate. After that, all persons supporting the appeal will be permitted to testify one at a time after being recognized by the chair. When those persons supporting the appeal are finished, those opposed to the appeal will then be permitted to testify and/or ask questions after being recognized by the chair. All persons wishing to testify, whether for or against the appeal may do so only after being sworn in. When testifying, each person must come forward to the podium after being recognized. You can use either one. Speak into the microphone and give us your name, address, and affiliation to the case. Any persons testifying will be limited to 4 minutes unless the board grants additional time. All testimony should be not directed to the audience, but to the board or the appellant. The board will hear only new, non-repetitive testimony. Should someone wish to show support of previous testimony, they may do so by following the procedures and stating their support. Now, will all persons who wish to give testimony this evening please stand? When in doubt, if you're going to talk, when in doubt, please stand up. And we can get this over with. Raise your right hand and swear and affirm. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Any changes to tonight's agenda?
Yes, we have one change. Case 11-2013 BZA, you'll see, has been removed from your agenda. We received a request from the applicant, Stan Messerly, he's the engineer on this project, stating that John and Monica Adams, the property owners, are requesting the extension so that they can further communicate with adjoining property owners and attempt to address any concerns or questions that they may have concerning the requested amendment.
Is it being withdrawn or just continued till next month?
They're requesting that it be continued until August.
And the August meeting is on
The
August
1st.
1st? Okay. And we have to take action to
Yes.
approve that. Entertain a motion to continue this case till August 1st.
I'll so move.
I'll second.
Any discussion? We have a motion and a second. Any discussion of that? Betty, could you call the roll, please?
Brian Ellis.
Aye.
Jeannie Bechtold.
Aye.
Steve Haver.
Aye.
Brian Johnson.
Aye.
Rick Oversmith.
Aye. So this case is continued for another month, August the 1st. Next up, we have case number 13-2013 BZA, property at 7286 Ticonderoga Court.
Can we do minutes?
Oh, I'm sorry. You want to do minutes?
Minutes and agenda.
Any other changes to the agenda? Minutes. We were talking last month about moving the minutes to the back, and I got ahead of myself.
No changes.
Any further changes to the
Move we
minutes?
accept minutes as published.
Second.
I did have a few changes from Rick in an email that I did make.
Typos.
Okay. Works.
Have a motion and a second. All in favor?
Aye.
I'll
right.
abstain. Brian wasn't here.
Okay, now we get to case 13-2013 BZA.
Yes.
Allison, could you give us a summary on that?
Our applicant for this is Robert C. Porter III. He's representing the property owner. This is 7286 Ticonderoga. It's zoned C residential. The variance is a request that an existing addition on the home that has a setback of 0 feet where 5 feet is required be permitted. The 5 feet is required per section 84.2 of our zoning resolution. Here we can see a location map of the property. Ticonderoga is off of Shangri-La. The tract is approximately .265 acres and has 60 feet of frontage on Ticonderoga. The topography there is relatively flat. The existing use is a single-family residence.
Allison, I'm having a little trouble hearing you.
Sorry.
Could we amp
It
that
is
up
turned
a little
on,
bit?
yes.
Thank you.
Sure. The surrounding zoning is all C residential and is used as single-family residences. So in this aerial photo, you can see surrounding conditions of single-family residences. The location of the proposed addition is approximately here. The home was purchased in 1960 by the Means, and the addition was constructed sometime after. The addition was brought to staff's attention earlier this year after a complaint was filed with our offices regarding the structure. No zoning history could be found for the addition. However, a zoning certificate was issued in 1991 for an accessory structure, which is a detached garage. There were also certificates in 1996 and 1998 for chain link fencing. This is the site plan that an applicant submitted showing the location of the addition approximately. Here we can see photos of the existing addition, as well as surrounding conditions on the street, as well as the structure directly across the road. Staff feels that the property in question will yield a reasonable return without the variance. The structure covers a side entry door, and its use does not alter the use of the property as a single-family residence. Staff is of the opinion that the variance is substantial. The applicant has stated that the setback of the structure is 0 feet, and the addition does extend to the property line, where the required setback is 5 feet. The essential character of the neighborhood would be altered, and adjoining properties could suffer a substantial detriment as a result of the variance. While the setback of other homes vary on the street, they do consistently maintain a side yard area free from structures. The spirit and intent of the zoning requirement would not be observed, and substantial justice not done by granting the variance.
Thank you. Any questions of staff at this time?
I had a question or two. In the applicant's remarks, they indicate a couple things, but one is they're indicating that that's perhaps a legal non-conforming use. What kind of, sure that was suggested to you when it first came up, what kind of investigation were you able to do to see how long it's there, when the zoning took effect?
Sure. The Hamilton County Auditor site does keep records of additions and accessory structures that they've noticed that have gone up, and generally they do have dates included if they were granted by Hamilton County prior to our zoning, and we did not find any for that addition.
Okay. So it showed up sometime afterwards?
Mm-hmm.
Okay. And what would be the key date on that, or key year?
That's a question for the applicant.
No, I mean, what would be
Oh,
the
for-
key year as far as determining if it was non-conforming or not?
Sure. The township got its own zoning in 1988, so prior to that, it would have had to meet Hamilton County standards, which were created sometime in the late 40s.
In the 40s, okay. Okay, thank you.
And just to tag on to that, the auditor's office would have tracked it only if there was a permit.
Typically, they track any addition that they notice on the home, and then, or accessory structure, and then do note whether or not it received a permit through Hamilton County.
I didn't think about that. Is it shown as a structure on
It
the
is not,
auditor's?
no.
Okay.
What's that,
On the
no?
auditor's
Correct.
drawing.
It's not shown.
It's not shown.
It's not bad.
Any other questions for staff? Would the applicant or its representative like to present its case to us, please?
My name is Robert C. Porter III. I'm an attorney. I represent Ms. Garnet White Mentz. She's seated here in the front row. She'll give some testimony. I want to thank the board for the opportunity to present this. I think it's important to note that this really isn't an accessory structure. This is a roof over of a side entrance to the property. And it's been there for a long time. It's been there, Ms. Mentz will testify, it's been there since sometime in the 90s, and she can give specific events as to when it showed up. When her husband constructed the roof and she'll explain various reasons why he did it. Obviously to shelter the side entrance, but from rain. But there were other reasons also, which she'll elaborate on. So to say that it affects the safety or the character of the neighborhood or it's been there for a long, long time. And it's in keeping with the character because there's if you go back to take a look at the plot map, the next door neighbor to the left has a roof over the side entrance also that, if you measured it out, we're not complaining about it or anything like that, but I mean, that would impinge on the 5-yard side yard step back also. So it's not unusual to have a roof coming off on the side entrance on these houses. Ms. Mentz keeps the property up, and if you had a chance to go out and view the property, you'd see that she keeps her property in very well-maintained, and I just don't, we're appealing to the good sense of the citizens on the Board of Zoning Appeals to, give her relief, not to have to tear down this roof over her side thing that has been there for decades. I mean, I think the reason this came about is made clear that there was a complaint probably sometime after December. It arose. I sent a letter to a neighbor, just asking him politely in a neighborly way not to trespass on Mrs. Ment's driveway. The insurance company wanted me to put the neighbor on notice that that in case there was a slip or fall or something, that they weren't really allowed to use her driveway for access to their property, and I think that upset them somehow, and then they made this complaint. But, for literally decades before, no one has ever complained about it. It's never been brought, to the attention, So the fact that it stands out or is substantial or affects the character of the neighborhood, I just don't think rings true, because it's been in that neighborhood, as I say, for a long time. As I say, I think it's a simple case that this roof, to say it's a structure is just, it's a roof over the side entrance. No one lives out there. There's no plumbing or any, any attempt to live in it. There's no structure, nothing stored in it. It's just a roof over a side entrance. I think with that, I'd yield my time to Ms. Mentz to make her statement and answer any questions you might have about when it came about.
Does anybody have any questions for Mr. Porter at this time, or do you want to hear from Ms. Mentz first?
I prefer hearing from the property owner, and then
we'll ask some questions.
Yes.
Okay.
Thank you.
If you could state your name and address for us.
Yes. My name is Garnet Mentz, and I live at 7286 Ticonderoga Court. My late husband, John Mentz, purchased our home in 1960. Together, we did many improvements to upgrade our home, including constructing a double driveway in order that we would be able to park our automobiles in our driveway and not contribute to the growing problem of automobiles congesting our street. Several months after the Patakas family moved to 1155 Shangri-La in 1995, and the house with the backyard that adjoins the right side of our house, garbage started appearing on the right side of our house. Garbage was even appearing on the right side of our roof and gutters. I finally spoke to Mrs. Patakis several times, and after blaming different animals, was told that the birds were responsible for the garbage all over our yard and gutters. Then one day, on the right side of our house, I found more garbage, along with an extra-large pizza box and an empty prescription envelope bearing the name William Patakis. Being completely frustrated by constantly picking up garbage from the right side of our house, I gathered up all of the garbage and took it to the Patakis house and handed it to Mrs. Patakis and told her to please stop throwing garbage into our yard. In 1997, the Duncan family that occupied the house next door to the Patakis family on Shangri-La erected a stockade fence across their backyard, and as many feet of the stockade fence allowed on the side that separated their yard from the Patakis yard, and then continued to the front side yard with the required open chain link fence. My late husband and I were made aware that the motive for the Duncan erecting the fence was due to the fact that one of the Patakis boys was urinating on the side of the Duncan house. And furthermore, if they could have done so, the Duncan family would have exclusively erected the stockade fence on the side adjoining the Patakis family property. Upon hearing this news in 1997, my late husband joined sections of the Duncan fencing on the right side of our house to shield our home from possibly the same fate of somebody urinating on our house. In addition, and at the same time, in 1997, my late husband put the little 4-by-4-foot roof extending from our side door to the property line, and thus completely separating our right side yard from the backyard of the Patakis family. Since 1997, this little roof has shielded the right side of my house and my right side door. The roof also shields me from twigs dropping from a huge tree in the Patakis' backyard that overhangs the right side of my yard and roof, and for which I have paid on numerous occasions a tree trimmer with a boomer to trim Patakis' tree branches away from my roof, inasmuch as it has never been done by them. Any consideration that the board can extend regarding a variance that will allow my little roof over my side door to remain will be greatly appreciated.
Thank you.
Thank you.
Questions for the applicant or the applicant's counsel? Mr. Porter, feel free to join in.
Is he asking a question?
They might.
May have questions. Any questions from the board?
I cannot hear him. I have a hearing.
I'm sorry, any questions for the applicant or applicant's
I'll ask
counsel?
Mr. Porter, and then he can relay the question, if it's helpful. When the roof was built in '97, was there any application made for zoning permit or building permit?
I don't know that we know the answer to that. I certainly did not make one. And do you know if there was any application made for a building permit in '97?
I have no way of knowing that.
The roof was built by her husband, so there was not a contractor hired or anything like that. I know that, but I don't know whether there was a building permit or not.
Can you, when you're on the property, can you get around the fence, well, I don't know what you'd call that, the kind of the covered porch area, I guess. Is it right on the property line, or is there room to get around it and stay on Mrs. Mintz's
Well, there's a lattice
property?
work.
No, there's no, it goes right to the, it goes out 4 feet. Actually, I think the entire, the entire house, the whole right side of the house, the only way to tell would be with the survey, but I suspect that the entire house would infringe in the 5-foot side yard setback by
It's
about a foot or 6.
skewed over a little bit,
We
you're
have
saying?
had the house surveyed previously, and it's right on the property line.
The outcropping is,
Yeah,
The-
the roof would go right to. the
Yeah,
property.
he
addition.
put like a lattice work and then the roof over it, so things wouldn't be thrown over into our yard. Or there was no access to our yard because of the problems we were having.
yes.
And that eliminated the problem completely.
Thank you.
I have a question. So the lattice work that's basically, that makes it appear to be a structure versus just the roof, was that put in at the same time, or was,
I can't hear her.
Was the lattice work put in the same time as the roof?
Yes,
that basically enclosed it and made it more of a structure than just a roof overhang?
I cannot understand. You need to talk into the microphone, I can't hear you.
I'm sorry. So when the roof was put on, the walls with lattice work that had basically enclosed your doorway, that's a side door to...
Right.
To a garage or your family room or somewhere in the house?
It leads to my basement.
Okay. So that was enclosed at the same time the roof was put on, so it's more than just...
Yeah, it was
the
all
roof.
done at the same time, yes, in 1997.
The lattice work, I was just out there, the lattice work is, it's... that-
Open.
It's open, it's that kind of, like, 1/4 inch thick by 2 inch, so it like crisscross square. It wouldn't provide any shelter from rain or anything like that blowing in. So it's not an enclosed structure by any means, but as she said, that lattice work prevents any kind of garbage or twigs or anything like that from getting into her side yard there, or at her doorstep, or going into the basement or wherever it is. So that's, I don't know what his thoughts were, but I think the lattice work was there just to provide some kind of
Protection.
protection from debris blowing under the door.
And it does protect it.
Are you able to get into your backyard from the back part of this structure?
Can you get to the backyard?
Uh-huh, if you go out your side door, can you go to your backyard?
Yes, I can get to my backyard.
Okay,
Yeah, that's all open.
okay.
There's no other gate or anything there.
Mr. Haber?
Mr. Porter, on page 2 of your document, you indicate that owner contends that her residence, which I'm assuming includes the addition that is under scrutiny at this moment, is a legal non-conforming use. So I'd like you to address that. Are you saying that because the structure extends into the side yard, that's the basis of this variance? I'm trying to get my head around the contends that your residence is a legal non-conforming use and hereby requests a variance.
Well, the non-conforming use comes from the whole, basically the whole right side of the, as I stated earlier, I believe the whole right side of, when the house was constructed, actually encroaches into the 5-foot side yard setback. I mean, if you look on the, and I know that Cages isn't all that, the Cages location thing, that there's not very much space between these, and I've actually been to the site and measured it. There's not much space between the right side of their house without even considering this roof. I hate to use the word enclosure or addition, because it's really just a roof over her, over this side door
That meets the lattice work.
yeah.
Well, there's some structure there that's been built.
Well, the lattice work is on the property, on the property line.
No, Mr. Porter, I'm trying to understand what you've written here, which is, I think is what you're saying is the basis of your appeal for a variance here, is that because the residence encroaches into the side yard,
Exactly.
that's
Yes.
the basis of a variance.
Yes.
That's exactly what I'm saying.
And I'm trying to get my head around that. I mean,
Yeah, so are we.
what is the hardship that you experience because the house extends into the side yard?
Well, the hardship would be if she was required to remove, something ancillary to her house, the use and enjoyment of her house, that it's been there, the house has been there since before
1950s, in the 50s,
before
55.
1960.
Yeah.
Right.
And so, I mean, if there was some problem with the house or the location of the house, something should have been done way before now.
Well, aren't we saying that the house was built in the 50s, the zoning code which established setbacks came later,
Oh, they
Correct.
did?
correct?
The setbacks came later. The house, I think, was built in
Right.
55.
Right.
And my husband bought it in 1960.
And the zoning code came at a later date,
Yes.
Zoning came in 1949,
1949?
thereabouts.
Okay. All right.
That
But
was
I-
the counts.
All right, all
What the
right.
zoning code said in 1949 is, we don't have in front of us.
We don't have it in front of, okay. All right.
I hate to debate dates and all that. I mean, the bottom line is it's been over a decade, at minimum over a decade that this has existed this way. And to substantially change the use and enjoyment of her house over a neighbor dispute is, I think you got the feel for it, it's just a little neighbor dispute, and it's not real. This isn't something that, she just put up and disregarded
No.
the requirements of Anderson. That was not her motivation. As you can see, when she did her garage and all that, she
Got permits.
got permits, and she wants to, that's not her motivation, is to avoid the zoning regulations of Anderson Township or anything like that. This has existed for a long time, and to require her to tear this down and substantially change her structure as it exists now would be a real hardship on her. That's why she's paid me, and that's why she's come up here, and you can feel the passion in her voice. She doesn't want to do that, and it's our argument that she really shouldn't have to. It's been that way for a long time. There's been no complaints. Her house is in keeping with all the rest of the neighborhood, and it's kept up well. And if we didn't have this little neighbor complaint,
Which
the government wouldn't be involved in it at all.
the complaint emanated from the fact that my insurance agent wanted me to put the Patakas on notice not to be using my driveway, trespassing on it all the time, using it like it was a sidewalk, because if my cars would drip oil or whatever and he would fall, he said he wanted to put him on notice not to be trespassing on my driveway all the time. They were using it to get in and out of their back of their house. And this went on continuously, day and night. So Robert wrote them a letter to please, I want to be a good neighbor. but they have to abide by the laws, not be trespassing on my property. Because it would fall on me to reward him if he would.
We understand that. That's
Well,
not relevant to...
I'm just saying, I feel it's retaliation. Within 90 days, then we get this about the roof, which it's not really hurting anybody. He said it's dripping water in his yard. That's what he said to me.
Any other questions of the applicant?
Anyway.
Thank you. Would anybody else like to speak in support of this application?
Yeah, I'd like to say a couple things.
Please. Please state your name and address.
My name's Greg Schroeder. I'm Mrs. Mintz's nephew, and my understanding of the facts is like Mr. Porter pointed out, the structure's been there for almost 2 decades and nary a complaint ever. And it was only until after the letter was sent to the neighbor notifying them of a liability issue. It was the middle of the winter time, so the slip and fall hazard, to avoid a potential lawsuit. Mr. Porter sent a letter to the neighbors. Now, within a few months after that is when this whole issue showed up. And in my opinion, it's nothing more than just a petty grudge against her because she had that letter sent. So, that's my opinion. I don't believe in coincidences, like all of a sudden, after 20 years, there's a problem with it. As Mr. Porter pointed out, the house to the left of hers, they also have an awning over their side door, which encroaches on that 5-foot setback. And in my opinion, this so-called structure amounts to nothing more than just an awning. It's an awning over the door with some lattice work around it. There's a gate in the front. She can access her backyard. It's not, to me, it's not aesthetically hurting her property or the backyard of the Patakeses. Is that their name? Patakes. So, thank you.
Thank you. Any questions? Thank you. Would anybody else like to speak in support of this application? Would anyone like to speak in opposition to this application? Please. Please state your name and address and affiliation of the case, please.
My name is Bill Patakas. I live at 1155 Shangri-La Drive. And the timing of the fence and the roof that's over her side yard is a little skewed, but that's okay. So when John erected the fence, we discussed it. He said that he was going to extend the fence that our other neighbors built after we had had a series of raccoon incidents in our trash. We spent a few $100s trapping over a course of 5 or 6 months, trapping the raccoons and releasing them. They kept coming back, and that created a trash issue, which Garnett is actually accurate on. There was trash that was going outside of our yard into other people's yards. When John built the fence, there was a time period in which he said, hey, we're going to put a roof over the side door, which I assumed was an awning, which is what simple metal structure or some structure that's attached to the house that's freestanding over the door. Instead, what we have is a 10 by 14 roof with side soffits, a top soffit across the long portion of the roof, and 3 4x4 posts that are concreted in and brickwork across the bottom of those. It's not a simple roof over a side door. There are other awnings in the neighborhood. I asked John about this a number of times. He was very ill the last few years of his life, and so I decided not going to deal with it, let John get over his illness, and unfortunately he didn't, and he passed away. I did address Garnett about the structure after John's passing, to which point she said, it's not my problem, etc. There were no permits issued, and as Garnett said, I should be following the law and not walking on her driveway, which were lots of kids, and I get that. And she's right to say that. And this is also the law, that there is a zoning permit, that there is a zoning regulation that says it needs to be 5 feet back. If the house is too close to the property line, that's okay, but there's still a zoning permit or requirement that says it needs to be resolved.
Any questions?
When was it built?
It was built in, the fence was done in '98, I believe. And I believe the extension to it was done a year later, roughly. And, you know, John had said we were going to put an awning up. We were actually out of town. We came home and there's this huge roof. It's, you know, it's not a 4-foot wide roof. It literally is 10 or 12 feet long.
Other questions? Thank you.
Okay.
Would the applicant or the applicant's represent, anybody else opposed to this, speak in opposition to this? If not, would the applicant or the applicant's representative like to make any final comment in response to what the opposition said?
I think the opposition backed up what we said, that it was in the 90s that this took place. It was done by Mrs. Ment's husband. He's been dead 5 or 6 years at least. If he had a complaint about it, I think the complaint should have been made in 1997 or 1998, not in 2013. I think just common sense shows that, I mean, I know you all know what the situation is, and you'll make the right decision.
Can I ask a follow-up question for you, though?
Sure.
The neighbor testified that this is more than a lattice work, that it's got some permanent posts holding it up, that it's got brick around the front.
It does not have brick around it. I was just out there today. I don't know whether, it does have some posts holding up the roof. I was just there today. There are some posts holding it up. There is lattice work, as I described. It's open. It's thin, you know, it's kind of like landscape lattice work that, you know, you might have vines growing up through or whatever. I didn't see any brick. It looked to me like it was wood, the side. I doubt, you know, John Mentz was an insurance man. I doubt he was a bricklayer or had the skills to, as the testimony was, he did this himself. He didn't have a contractor do it, and it looked to me like it was all wood, nails.
Okay.
I doubt there was any, I mean, if there's concrete in the, supporting the, is there concrete in there?
There's just some bricks along the bottom to keep the water from coming in. And he put up a gate, and the posts were the...
Excuse me, ma'am, could you go ahead and come back up so we can pick you up on the microphones?
She has a better idea than I was going to say, I was out there today.
Well, the thing is, he put the 2 posts up because he also put a gate, again, to keep the garbage out and the animals out and whatever. And then we had a problem with people trespassing too, so he put it, and that's what the posts are there for. And the bricks he's talking about were just I put those along the bottom. That's where the bricks are.
Okay.
They're just laying there, they're not cemented.
Thank you. Any other questions of the applicant?
I'm still a little bit confused whether it's a 4x4 or a 10x14. That's a significant difference. I don't know if anybody's able to answer.
Would the applicant?
It's definitely not 10 by 14. I measured, 10 by 14 would be encroaching onto their property. The house, as I say, is probably within 4 feet of the property line. And so it goes right to the property line, the roof, so it's 4 foot out.
Do we have an aerial photo of it?
Not one without tree coverage.
Oh, just the trees are in the way. I got you. Thank you.
All right.
I have, I don't know if this is part of, can I approach the?
Yes, certainly. It's one of those drawings that if we don't have it already and we need to keep it in our record.
I think we've got that. Is this the one you have?
Yeah.
Okay, yeah, we do have that.
It's hard to tell. It's this white area here.
Yeah, we do have that, thank you.
That's, and then on the, on the house next door, you can see there's a similar thing.
It looks like it's about,
Might
we're
need
trying to get
you
some
back to the
scale.
microphone there, Mr. Porter, so we
Well,
can pick it up.
well, maybe while he's up here, though, I could ask him. I'm just trying to get some scale, so Ms. Hodson put that in pink there, and see how it is relative to the size of that car? It's about 2/3 the size of that car, it looks like.
See this white area here, that's the,
Yeah.
that's 4 foot that width there.
Yeah,
And so that's where I got the 4x4. It looks like it's relatively square. Maybe not exactly, but that is it there. And this was in 2001. I got this from your zoning people, the Cage's map. They supplied it to me, and that's where it is. That's it. And as I say, I've measured with a tape measure out from the house, and that's 4 foot.
4 foot. To the wall or to the peak of the roof?
No, from the wall out. The
I
width.
understand the wall of the house out to where the wall and lattice is, or out to where the peak of the roof is?
I mean, the end of the roof.
Yeah,
Yeah,
I'm sorry,
out
the
to
end.
the end of the roof. The lattice work is right below the peak of the roof.
Okay,
So there's nothing that extends beyond.
it doesn't extend over. Thank you.
Any other questions? If not, we're going to close the public hearing on case,
Can we ask a question of staff still, though?
oh, yes, please, go ahead.
Okay. If it were a fence there, and that's a side yard, right? Could that be a privacy fence there?
No, it could not.
And would it have to be set back off the property line?
It would not, no.
It could be on the
It would be
property
on the
line?
property line. It would have to be at a maximum 4 feet high, and it would need to be 75% open.
Kind of like a, yeah, okay.
Split rail Kentucky.
So it could have a
Bourbon.
fence there
Mhm.
on the property line?
Sure.
Okay. Okay.
Thank you.
Oh, I'm sorry. And so there's been some testimony, we had comment in the staff report that this was not in keeping with the neighborhood, because when you went through, you didn't see these
No,
types of
there
out structures.
are-
But there were some comment by the applicant that it is in keeping. What's your thoughts
Sure.
on that?
There are some, not the greatest photo on the bottom there. You can see there are some awnings and roof structures over both front and side door
Mm-hmm.
entries to homes here. However, most of those do maintain side yard clearance.
It looks like in that picture, the roof overhangs the wall to me. Am I just... I guess that's not a question, I'm sorry.
We can't take testimony right now from the audience, thank you.
I don't have any more questions, thank you.
All right, with that, we're going to close the public hearing on case 13-2013 BZA. Just as a matter of procedure, we go ahead and hold all the public hearings, and then we'll come back and deliberate on the various cases. So with that, we'll move to the public hearing on case 14-2013 BZA, 7062 5 Mile Road. Allison, would you like to?
Sorry, I'm already seeing a typo. The property owner and applicant here is Bryant Feistel. This is 7062 5 Mile Road, zoned AA, which is a single-family designation. The variance request is for the rear setback of an addition to be 25.71, where 60 feet is required in the rear yard. Here we see a location map of the property along 5 Mile. You can see it's quite close to I-275. Across the street is the Winthrop Nature Preserve. Surrounding zoning is all AA residents. In addition to I-275 and the Nature Preserve, there are single-family residences both to the east and west. This tract is approximately 1.14 acres, and it has 293 feet of frontage on 5 Mile. There's an increasing grade to the north, and the existing use is a single-family residence. Here we can see an aerial photo of the surrounding conditions. So the applicant is proposing several additions onto the existing home, which you can see here in their site plan. Primarily, the additions take place on the west side of the existing structure. The topography there is best suited for the addition. To the north, there's a small addition being proposed, as well as several porches. The addition does go 25.71 feet to the rear property line, where that 60 feet is required. The home was recently purchased by the Feistels, and they are seeking to occupy the residence along with Mrs. Feistel's mother. The only previous zoning certificate on file is for the accessory structure, which was issued in 1996, so the home was built prior to our own zoning certificates. Here are proposed elevations of the structure, as well as photos of the existing conditions. You can see both in the first one, that's conditions to the west, to the north, to the east, and then finally to the south, looking at the nature preserve. Staff is of the opinion that the variance is not substantial. The existing setback of the home is 35.71 feet, where 60 feet would typically be required. The essential character of the neighborhood will not be substantially altered, and adjoining properties will not suffer a substantial detriment as a result of the variance. The primary location of the addition is onto the west side of the home, where the size of the parcel and the topography of the site will best accommodate the work. The additions will not significantly alter surrounding parcels. The additions onto the northern side of the structure are adjacent to I-275. The variance will not affect the delivery of governmental services. The property owner's predicament cannot be feasibly obviated by some method other than a variance. Much of the work taking place is to make the house more accommodating for Mrs. Feistel's mother, and the applicant has kept the majority of the addition focused to the western side of the existing structure and is able to meet setbacks in that location. The spirit and intent of the zoning resolution will be upheld and substantial justice done by granting the variance. The rear of the property is adjacent to I-275 rather than another residence where keeping an open rear yard would be within character.
Questions of staff? Any questions? No. I have one question, Allison. Obviously, the existing house setback is 35 feet.
Yes,
Do we have any records on that? Is that because of the taking for I-75, 275 rather, in the early 70s, late 60s?
I believe so.
All right, thank you.
Yes.
I believe so, yeah.
Thank you. Would the applicant like to come forward, or the applicant's representative? Please state your name, address, affiliation to the case.
Brian Feistel, 6051 Wayside, owner.
Anything else you'd like to tell us about the application?
Well, it's a mountainside there, and I got the architect lady, and I had an idea, but she said, hey, you're going to fall off the hill, so we got to do it this way. So I'm here to throw myself on the mercy of the court, so to speak.
Questions for the applicant?
Do you happen to know, I know you just bought it, but do you happen to know, as Mr. Oberschmidt was questioning, what is the situation, why it has that reduced rear yard? Is it, obviously the highway's back there?
Well, actually, I think that the Mutersbach family, when the property was sold years ago, to give the next-door neighbor 2 acres, they sort of cut their backyard short and said, you got 2 acres.
So they're allowed to subdivide it then anyway?
Yeah, the original Mutersbach farm was the whole area, and then on top of the Withrow Nature Preserve.
I see.
That was part of the Mutersbach family, too.
Okay, thanks.
And if you'd like our architect here, she'll answer any questions that you have.
We'll get you up next. What question for you? Other questions for the
I
applicant?
do have one. There's a lot of greenery back there. When any of the trees need to be, the screening and the trees to the rear, is that going to have to go away?
The only thing that's going to hopefully have to go away is a bunch of dead ash trees. But when we bought the place, it was winter. I didn't realize that Anderson Township had so many ash trees. But they'll all be there.
Okay.
Other questions of the applicant?
Okay.
I had just one question from you. From the rear, where you've got this proposed addition, can you even see any houses on either side of you?
No. No.
There's nobody within?
It's, if you look at the aerial there, it's in the way up in the corner there. The entrance to the Withrow Nature Preserve, if you kind of go out there to the left, you can see the next-door neighbor's house, and then way over to the other left, excuse me, I'm dyslexic, to the right, you see one neighbor, and to the other left, you'll see another, but it's pretty densely wooded.
Okay, thank you.
I'll let you talk to our architect lady.
All right, would you like to come? Give us your name, address, affiliation to the case.
My name is Sally Noble, and I'll just give you my office address. It's 413 Wyoming Avenue, Cincinnati, Ohio, 45215. So I could just briefly explain the process that we went through is that the Feistels purchased this property with the house on it and wanted to add on to the rear of the house. And I said, well, the first thing we need to do is survey the property and everything. So that's where we found out that the property wasn't, not where we thought. They thought they owned all the way back to 275 when they found that wasn't the case. And along with that, I said that you have got all this empty space along the one side of the property. It's the flattest part of the lot. I feel like it would increase the curb appeal of the property. It wouldn't encroach on the driveway and the contours of the existing property. It would be the easiest to add on to. It would be the most attractive. And then it would leave as much as possible of the existing house intact so that we're sort of keeping all of the construction outside besides the renovation and the interiors to the outside to make it the most cost-effective way to add on. Now, we did add on to the rear because the house is pretty narrow and there was one room that we just couldn't work within the footprint, and we decided that we would just go for that, go for the back, and so we could make the room, livable, the bedroom. So that was kind of the line of reasoning, and that it would look best from the street and be the least invasive of the existing topography and also of the natural, vegetation on the property. So that was kind of my ideas.
Thank you. Questions? Any questions? Doesn't appear to be any. Thank you. Would anybody else like to speak in support of this? Would anybody like to speak in opposition to this application? Hearing none, we'll close the public hearing on case number 14-2013 BZA, and like I said before, we'll take it up for consideration after we hold the public hearings on the other cases. Case 15-2013 BZA, property at 8653 Forest Pine.
If you're tired of hearing me, we have Andrew, our co-op student for this quarter. He's going to present this one.
All right, thank you. Andrew, please.
My name is Andrew Benoit. I'm a co-op student at the University of Cincinnati. This is case number 15-2013 BZA. The applicant is Paula Bartholomew. She's the property owner at 8653 Forest Pine Drive. The request is for a variance to allow a pool in a portion of the front yard area where it is required to be located in the rear yard per section 171.7 of the zoning resolution. The location map, you can see that it's a corner lot located on Forest Pine Drive and Nordyke Road. If you go to the aerial, you can see that it's primarily residential in this area. There was not a site plan submitted with the application, so Allison actually drew up a sketch. But as I said, the applicant is proposing the installation of an above-ground pool with a diameter of 21 feet within a portion of the front yard area. The pool would extend approximately 11 feet into the front yard setback along Nordyke Road. Staff is of the opinion that the variance is not substantial. The proposed location of the pool is positioned in a portion of the front yard of a corner lot. Although the proposed pool would encroach on the 40-foot setback requirement for this residence, the encroachment would only be 11 feet, and the septic tank in the rear yard provides no other option for the location of the pool. The essential character of the neighborhood would not be substantially altered, and adjoining properties would not suffer a substantial detriment as a result of the variance requested. The adjacent properties are primarily screened from the proposed pool by a number of trees along with a fence. The portion of the pool which is to be positioned in the front yard will be built into the hillside, screening it from neighboring residents. As we've said, the property owner's predicament could not be feasibly obviated by placing the structure entirely within the rear yard area, as an existing septic tank makes the location unfit. And here are some pictures of the site in the backyard and front yard.
Okay. Any questions of staff on this application?
Could we look at the Cages map again with the little blue dot on it? Yeah. So if, Mr. Benoit, if this was not a corner lot, would that be its rear yard?
Yes, if it was, the frontage was on Forest Pine.
Yeah. Thank you.
Our favorite corner lot issues.
Oh, boy.
Any other questions of staff? Would the applicant or the applicant's representative like to pick a microphone and give us your name and address? Tell us a little bit about the application, please.
Hi, I'm Paula Bartholomew. My address is 8653 Forest Pine Drive, 45255. We attempted to, we in fact had purchased the pool, put the deposit down, had the installer come into the original site where we had had the permit, which is over, I guess, to the right, next to the property line. And when they arrived and they surveyed, and they then, because it is on a slope, said that they would have to go down 36 inches into the ground to level it out, and then of course you're onto the septic tank. And when they installed it, they would have to come out and around and cross the septic tank lines several times in order to install it. And at that time, he said that the best place for it would be where the blue dot is. And it wouldn't, I don't believe that it would go quite 11 feet out. It would only be 9 or 10, the way he described it and positioned it and drew the circle. And it is blocked by landscaping. And it will be 40 inches into the ground, into the slope.
Questions for the applicant?
So it looks like it's going to, from what I read, it's above ground, but you're actually going to put it up to your deck, right? So you can walk right off the deck into it.
Right. And then, once we get the determination of tonight, expand the deck and, redo our backyard.
Thank you.
Other questions? Is there excuse me, there's one more. Is there a plan, does it include like a walkway around it or fencing around it or anything special like that, or is it?
Not at this time. I wanted to get a determination on tonight as to how we're going to handle this and then proceed. I mean, of course, if I get denied, then there's nothing I can do. But once the gentleman comes, our contractor for the deck, I will get him to give me plans. But I would like to tear it down and do some sort of walkway down to the deck. Concrete, rocks, whatever.
But you're not going to have any deck structures that go around this pool, so
No.
my question is, if we grant you a variance for the pool, are we?
No, I want it to come down to the deck and do like rockscaping
I
around
gotcha.
it and grasses on the backside of it.
Okay, thank you. Other questions? Anybody else like to speak in support of this application? Anybody like to speak in opposition to this application? Hearing none, we'll close the public hearing on case 15-2013 BZA. Move to our final case, 16-2013 BZA, 7967 Ayers Road.
Yes. And that's it. The location is a shared driveway, but this is the primary residence adjacent to the street in that location. So this area is zoned AA residence, it's single-family designation, and the variance request is to allow a portion of 2 decorative columns on a shared driveway to be located partially within the right-of-way, where they're required to be completely outside of the right-of-way per section 171.26. Altogether, these lots are well over 10 acres, and there's approximately 314 feet of frontage directly on Ayers here. This is the location of a shared driveway, and in this aerial photo, you can see the beginning of the construction process of that shared driveway, which will serve multiple lots back in this area. Surrounding zoning is all AA, single-family, and then to the north of these lots, which are quite deep there is some H riverfront zoning. The applicant is proposing to construct 2 columns, 6 feet in height, located partially on private property and partially within the right-of-way. The zoning history at this location is that the Riverview Estates at Coldstream subdivision, consisting of 20 parcels, was approved in 2007. In January of 2012, a zoning certificate was issued for the construction of this first residence off of the shared driveway. A pool, fence, and an accessory structure were issued zoning certificates in May and June of 2012 as well. Here's some photos of surrounding conditions. The need for the location of the columns to be partially within the right-of-way is somewhat dictated by the existence of this. Because of the utilities in this location, it's not possible to place the columns directly there. The staff feels that the variance is not substantial. Our Public Works Director, Richard Shelley, has provided his approval of the location of the columns and has stated that they will not impact the Public Works Department's ability to maintain the road. The essential character of the neighborhood will not be altered, and adjoining properties will not suffer a substantial detriment as a result of the variance. The subdivision features a variety of architectural styles and large-scale homes where the columns would not be out of character. The variance will not adversely affect the delivery of government services. As stated, Richard Shelley has verified that the proposed location will not impact the roadway. The property owner's predicament cannot be feasibly obviated through some method other than a variance. The columns cannot be located entirely on the private property due to these utilities. And finally, the spirit and intent of the zoning resolution will be observed and substantial justice done by granting the variance. The proposed location of the columns will not negatively impact the use of the roadway or this private drive.
Could I just make a quick disclosure?
Sure.
I see Mr. Arnold is indicated as the applicant, although he's not here. I know him professionally and has actually done some work for my employer, but I just want to disclose that.
Sure.
I don't feel it's any kind of conflict, but I thought I'd just mention it. Thank you.
Any questions of staff on this
Yeah.
application?
Where are the utilities that are preventing these from being built on the owner's property?
Sure. In this photo, you can see this would be the ideal location for the column. The applicant would love to put it there, but this is quite in the way. And in order to mimic them on both sides, the columns would need to be shifted upward slightly to have kind of a mirrored appearance.
Okay. And they're only on that one side?
Yes. Mm-hmm.
There isn't anything preventing the other column being located on the owner's property?
I do not believe so.
Okay, so the conflict is only on the one side?
Yes.
Okay.
Other questions of staff?
I'm assuming the right-of-way line in the back of pavement, the curb, the trees that are shown in this one picture, in this lower right-hand corner, those trees planted by the developer, and those are in the right-of-way?
Correct.
And are the utilities in the right-of-way, or is that on the owner's property?
This is on the owner's personal property.
Okay. Okay.
So you indicated Mr. Shelley is okay with
Yes.
this. They'll also have to get some kind of right-of-way permit or something, will they not, from the
Correct.
county?
Yep.
So if the county grants them a right-of-way permit to put it in the right-of-way,
Well, in this
does the
case, it would
board-
be through the Public Works Department because it's not a county street.
Oh, I'm sorry. So okay, I get it. So Mr. Shelley is the one that can grant that permit, not the county. Okay. So if he was okay with it, you still need approval from the zoning board?
It's still, yeah, there's still that section of the zoning resolution that asks for all.
Says to keep it out of the
Yep.
right-of-way. Okay. Thank you.
And I'm assuming that Mr. Shelley speaks for emergency services, fire?
Yes, Fire and Rescue has taken a look at this as well.
Other questions? Just one quick one, just for my clarification. How many residences will be served by the driveway?
I believe 5.
Okay. Would the applicant or the applicant's representative like to come forward and say anything else about this? Just state your name and then...
Hi, my name's Joe Ferrugia. I'm with Zicka Homes. The driveway that services the 5 lots is 18 foot wide. And we tried to figure out where to put these columns, which will enhance the 5 lots and the homes on that private drive. And we do have utilities that run along the back of the curb and also that run down the private drive. So that's why we're asking for the variance. Because of the utilities, we are forced to encroach into the right-of-way some with the pillars. The right side of the driveway, there's some fairly large trees that have been planted in there. We prefer not to move the trees. We'd like to have the pillars the same distance back from the curb on each side.
Questions for the applicant?
There's no intentions of installing any gates. This is just going to be kind of, again, an entrance gateway type.
Yes,
appeal.
just the pillars only. We'll put lighting and landscaping around them.
Any other questions of the,
And I guess the maintenance of it is going to be accepted by the homeowners association? or
Yes.
And not the township?
It's the homeowners association's responsibility to maintain the pillars, landscaping, and the private drive.
Mr. Haber asked a question about, could one column be, I guess, not in the right-of-way and one in? Is that your understanding, or would they both be in
They would both encroach into the right-of-way.
to keep them even?
The base is 3 by 3, 3 feet by 3 feet, and about half of that will encroach into the right-of-way. And one, for aesthetics, and then two, there's some trees on the right side of that drive that would be a problem.
Thanks.
other questions? I have one question. Do you know, you spoke of landscaping around the pillars. Is the landscaping going to be extensive or minor, or?
It'll be attractive landscaping, more bushes around the base of it, not anything large. And that, again, is maintained by the homeowners association.
Okay. Thank you.
Thank you.
Would anybody else like to speak in support of this application? Would anybody like to speak in opposition to this application? Hearing none, we'll close public hearing on consideration on case 16, 2013. Okay, back to the top. Case 13-2013, Ticonderoga Court. Just for those in the audience, at this stage, this will be a discussion among the board as it deliberates the case and is not open for any further comments from the audience or the applicants. So I open this one up for discussion or consideration.
Right, well, it's always difficult, but these cases find their way to our board sometimes when there's neighborhood problems, and nobody likes to see that, and I know I don't, and so I'm hopeful that, you know, everybody works everything out. But I guess the way I would look at it is I kind of have to take a couple things off the table from my perspective, and one is how long it's been there, and two is that there's a neighbor dispute. So I'm disappointed that we're having to hear it in the context that there's a neighbor dispute, but I guess the way I would look at it is if the property owner came to this board and said, I would like to have a variance to construct this next month, and here's what I'm asking for, this fencing structure, fencing/wall structure with a I would say in my view, I did go out and look at it, it's fairly substantial roof, et cetera. Would we approve that? And so then we would look at the criteria that the courts have set out for this board to look at, one of which, by the way, unfortunately, or fortunately, I guess depends on, is not how long it's been there. That's not a consideration of my understanding of what this board looks at. So we do look at things like, is it in keeping with the neighborhood, is the variance substantial, et cetera. Now, my view was, when I went out there, I agreed with the staff remarks, essentially, that I didn't see a lot of these types of side extensions off the houses. Also, the lots there, it's a very charming neighborhood. I really like the feel of it, but it's close. And so I think when you have a extension off the side of the home that goes right up to the property line, it can have an impact on the adjoining neighbor, and it can feel like that space, the setback space is intended to keep some opening between the two, and I believe we heard testimony that you cannot even walk along the outer part of that structure without being on the neighbor's property. So, you know, I hear what Mr. Porter's saying about, you know, look, this has been there a long time. Does it make common sense to have it torn down or find it in violation? It's really troubling. However, I guess, you know, my view is I'm trying to take a look at it from a fresh standpoint, forget about the conflict, and I'm not seeing it as being in keeping with the neighborhood, nor necessarily, really, I didn't hear that it met any of the variance criteria. So I'm not sure there's support for it in the record.
Thank you, Mr. Elf. Other thoughts on this?
In keeping with Brian's comments, I'm in agreement, and I like his approach that if this were a new appeal, not having been built, would we consider it and approve it? And so in getting the rest of the issues that Brian mentioned off the table, that we would allow something with a zero setback, not only an awning, but an addition that has enclosure and permanent construction to it, with a zero setback on a side yard, I think is we need to be very careful with, that we don't establish a precedent given the sensitivities, and I'm sensitive to the neighbors and whatnot, but I am having a tough time in support of the variance, given what I think were the line that Brian took. They said, would we approve this if it wasn't there? And I frankly have not been able to substantiate, in my mind, approval of it.
Thoughts, Brian or Jeannie?
I was thinking the same way about the appeal as a new appeal. The house itself is within the 5-foot setback, and the variance seems to be for the roof, but the whole extension is within the 5-foot setback. And I don't doubt the motives for putting it there. I appreciate that, but I agree with the staff's findings, and I'm not sure I can support a zero setback.
I agree with all of you, is that it's an unfortunate situation, but it's more than just a roof overhang to protect the entrance. It does appear to block the entire side of that house through the, and it does not meet, I did the same thing, I drove through the neighborhood. I didn't see any other structures that were basically separating the one property line from the other house. You know, they are very close. And when you have a very close neighborhood like that, the houses close together, there's that area between the houses is what gives it a little bit of space and character. So I agree that if this would have been brought to us, it would be difficult for us to grant, and I'm in agreement with what the staff has submitted.
And I don't think I take the same tact as the rest of you do on it. I had a couple of different thoughts. One is, it might be a little different if this was side yard to side yard, but this is side yard to rear yard. And the other house, it's the rear side of the other house, I believe, that faces the other street. So while it is zero setback to the property line, I don't think it's anywhere close to the other residents. My second thought was, okay, you can take it down and put a fence up. Certainly the fence has to be open and all that kind of stuff, but you can build something right there as a fence. And then my final one is while we do, the fact that it's been there for somewhere around 16 years or so doesn't give it justification. In my mind, it does show that it hasn't substantially altered the essential character of the neighborhood, because if it had, we'd have heard about it probably long before now. So I do think that 16 years of being there does indicate that it is somewhat consistent with the character of the neighborhood. But, so those are my three thoughts that are somewhat different than yours, but that's why we're all up here. Excuse us while we switch tapes. It's not tapes anymore, discs, showing my age.
We get to your party on the plaza.
Was that the party out there?
Yeah.
Are we still on TV?
Yeah.
Oh, I can't tell my wife that we're going to go late tonight.
Okay.
All right, back on.
I do have a question regarding zero setback. Has there ever been a variance that has granted a 0-foot setback that has allowed a residential structure to be built to the property line?
I'd have to do some research on that one.
Yeah. I mean, I understand the rear yard, side yard connection here as being, you know, a means of going there, but my concern is that if we allow a zero setback here, what that will do to the Borden, unless we couch that portion of the motion very carefully.
I would also make, I guess, a responsive remark on the fence, and I did ask that question about, could you put a privacy fence there, and the answer was no. You have to put one of these side yard compatible fences there, which is substantially more open than a privacy fence, which I'd say a privacy fence is more akin to this structure than you know, one of these side yard fences. So I think you know, I think you could put the fence up there. You would create that separation, but it would not be right there on the property line.
Any other comments or discussion?
You know, I just think if it were the roof and to protect the entrance, I wouldn't have a problem with it, but because it has walls and is more of a more permanent structure, and does create that barrier between the house and the adjoining property, and there is But that's what I'm struggling with, is that it's more of a structure than just an overhang, roof overhang, or an awning, is what we discussed.
Certainly, when I drove by the other night, I thought it was more than a roof, at least from the street. It
Yes,
appears to be far
in
more
the
than a
pictures,
roof.
yeah.
Anything else? Just as a matter of procedure, what we do is that we'll take a straw vote if somebody makes a motion. That is not our final vote. We then usually have a discussion of a motion and what a resolution would look like, and then we get it typed out and make that final vote on that either tonight or at our next meeting. But we do take a straw vote to see where we stand. So with that, any further, anybody care to make a motion on this one?
I'll take a shot at making a motion in case number 13-2013, 7286 Ticonderoga Court. I move that the board deny the requested variance for a setback from 0 feet to 5 feet, with the findings that the property in question will yield a reasonable return and can be put to beneficial use without the variance, as there is an existing home there. There was an existing home prior to the structure being built, and there are many homes in the area without this type of structure. Also, that the variance is substantial, as that it would go up to the entirety of the side yard setback and go right up to the property line, and that the bulk of the side addition is noticeable and includes not only walls but a roof. The essential character of the neighborhood would be substantially altered, and the adjoining property owner would suffer substantial detriment if the variance was granted, in that the evidence has shown that there really are not these types of side additions in that neighborhood. This is a neighborhood of smaller lots, closely set together with minimal setbacks, and by virtue of this structure, that would be substantially changed if this were allowed. The variance does not have any effect on government services. We did have evidence that the property owner purchased the property and does have at least some knowledge of the zoning, in that prior zoning certificates had been applied for. Property owners' predicament could be feasibly obviated without the variance. We did not hear that the side addition was critical for maintaining the use of the house, and we also heard indication that there could be fencing that is less obtrusive to be installed and that would maintain some separation. So therefore, the spirit and intent behind the zoning requirements would not be observed, and substantial justice not done if this variance were granted.
I second.
We have a motion and a second. Any further discussion? Okay, Betty, would you call the roll, please?
Brian Hall.
Aye.
Amy Bechtold.
Aye.
Steve Haver.
Aye.
Brian Johnson.
Aye.
Rick Smith.
Nay. Okay, on this one, that's a straw vote. I'm fairly confident that we will not take the final action tonight, because we will want to have the resolution typed up and reviewed before an action at the next month's meeting. Okay.
Thank you for your consideration.
You're welcome. Case 14, 2013, BZA, 7062 5 Mile Road. Any comments on this case? Other than I threw the red herring out there by 275. I thought this went right up to 275. I didn't realize there was property behind it. Apologize for that to the board.
We're on 147062 5 Mile?
Yes.
Okay.
Thoughts or comments on this one?
I think that they've looked at it and are asking for the variance and trying to improve the property. I think it's going to be an asset to the site to improve the house, and they're working with the footprint that they have, and I think it'll be a great improvement. I don't have any problems with granting the variance.
Yeah, it did look like, too, when I looked at it, although we don't see topo on this, I think they've got some topo issues back there. The lot is quite large, so there's room for expansion. The bulk of this expansion is really being away from the nearest occupied structure, so there seems to be some good standing under the variance criteria that there would be to issue the variance. And although there is a interceding lot between it and the interstate, this lot is still affected by the interstate. So if there's a slightly more intensive use of the residential structure there, I think it's going to be minimal, if no impact at all on the area.
Any other thoughts on this? Brian? Yeah, I agree. When you drive by it, there's some hillside there, and there's a lot of vegetation around it, and this seems like the only logical location for this type of an addition, and we certainly our plans are the plans for the township and its master plan is to encourage its continued residential development and improvement, and this is one of those things.
Absolutely.
Okay.
Mr. Chair, in the case number 14-2013 BZA, I move that we approve the variance request for a rear setback of an addition to be 27 feet where 60 feet is required per section 64.3 of the Anderson zoning code. And for the following reasons, that staff is of the opinion that the variance is not substantial due to the location of the residence to the rear lot line, and we've understood that some of that property was taken with the insertion of I-275, that the setback was made non-conforming, so any work back there that could have been done originally would necessitate a variance. Because of the size of the properties, and we've talked about the location of the addition as being on the opposite side of the existing house relative to the nearest adjacent residences, that the essential character of the neighborhoods are not going to be substantially altered. Adjoining properties are not going to suffer a substantial detriment if we allow the encroachment into the rear yard. True, the primary location of the additions is over onto the west side of the structure, which are in, as staff has indicated, are in conformance with required setbacks. The topography into the rear goes up significantly, thus increasing costs and whatnot for an addition to go on the rear of the existing house. Addition's not going to significantly affect any surrounding parcels. It's not going to affect the delivery of governmental services. So we're saying that the owner's predicament cannot be resolved by some other method than granting this variance. I would also make the following stipulations: that the variance granted is in accordance with the drawings dated June 20th, 2013, drawings V0 through V-4, that construction be commenced within 1 year and completed within 2.
What was it, what was the time frame?
Construction commenced within 1 year and completed within 2.
I'll second that.
Motion and a second, discussion.
I'm sorry, I should have voted.
No, you're fine. I guess my only discussion on it is I think we could probably add, in this case, one more, because the property owner testified that they thought their property, when they bought it, went further back, all the way to the interstate, and then found there was this intervening piece of property. So I think this is one of those cases we don't get too often where the property owner didn't understand, didn't have knowledge of that zoning restriction. So if we can include that in the reasons.
Good add.
All right, we have a motion and a second. Betty, could you call the roll, please?
Brian Ellis.
Aye.
Jimmy Bexell.
Aye.
Steve Hager.
Aye.
Brian Johnson.
Aye.
Rick Oversmith.
Aye. Case 15-2013 BZA. Swimming pool, 86534 Forest Pond. I'll make this initial observation while you, when I read it on paper, I thought, what? But when you look at the site, and the fact that they're really, it's not like it's not even adjoining other residential property to speak of. It's adjoining, frankly, a busy road.
Very busy road.
It is well surrounded. So this one came out different when I looked at it in person than when I read it on paper.
I also think that the issue with the septic system being in the way, and there really isn't probably any other good place to put the pool. They're trying to make it fit in as well as they can into their, I guess if you want to call it their rear yard, without being too intrusive to the frontage on Nordyke. I was wondering why I wanted to put it over there, and then I read about the septic system, so that is something they need to consider, and it's not something that's not easily moved.
Yeah, on a variance for a side yard and a pool, usually I'd give it a double look on above ground, but in this case, the above ground actually works really well because it's going to come right on the deck. They've got a lot of slope on the back of that yard, and yeah, I agree with what else has been said as far as it not going to be that noticeable, so I think it's in good standing.
And one other thing that I thought about as I was driving around the township, while it's going to be visible, this is not a permanent structure for eternity, such as a house. Above-ground pools, have a limited life. Hope it's longer than others, but that's the other thing. If this were going to be a shed or an addition or something more permanent, I would have more reservations, but because it's not, that's another thing that swayed me too.
Steve, Brian?
Yeah, I'm in agreement with everything. The concerns that I think that we've raised is either landscaping or additional deck construction or something, and absent a better plan than what has been presented to us. I think we need to have some kind of language that recognizes additional structure, so that, yes, we could allow the pool, and the pool's going to be inserted into the most appropriate place, but there's some limitations as to additional structure or something like that.
Yeah, I agree with that concern. Obviously, I asked a couple of questions about it, that, is it going to end up growing into something bigger than an authorized above-ground pool? So that's an interesting point.
Right. I mean, typically, we have plans that are presented, and I understand the circumstance. I'm just cautioning us to add some language.
Like I say, I understand the applicant's predicament with the lot configuration and the septic issues. My concern was that it's not only a side yard pool, but it actually comes into the front yard as well. So I was kind of having some problems with that it wasn't just side, it was a little forward.
With our corner lot issues.
Well, is the...
Someday before I leave this board, we'll rewrite the corner lot.
Is the front yard on Forest or is the front yard on Nordyke?
Both. With a corner lot, we have 2 front yards. A portion of the pool, approximately 10 feet, will be located within the rear yard, and a portion, approximately 10 feet, will be located within the front yard.
Okay. So on corner lots, you just get the added front yard?
Have your 2 front yards.
2 front yards.
Yep. Yep.
I think we have one every meeting, don't we?
I think we have one every meeting. Any further discussion, concerns about Brian's point? Not, I'm happy to entertain a motion.
You want to do it since you wanted to put your additional structure stuff in there?
Well, I haven't gotten my head around how I was going to word it yet. Okay, and Mr. Chair.
That's why it's a straw vote.
Case number 15-2013 BZA, I move that we approve a variance request to allow a pool in a portion of the front yard area where it is required to be located in the rear yard per section 171.7. Under the following reasons, most importantly, because we have a corner lot situation where there are 2 front yards, and the location of the septic system, which would allow the pool to be located further away from Nordyke, that because of those 2 things, the corner lot as well as in the location of the septic tank provides no other option for the location of the pool other than what is shown on the drawing. So primarily because of site constraints, that the location variance would be granted. We've had testimony and talked about that the essential character of the neighborhood would not be altered and adjoining properties would not suffer a substantial detriment if we approve the variance request. The adjacent properties are screened from the proposed pool by a number of trees. And again, regarding the site, the portion of the pool which is to be positioned in a portion of the front yard is going to be built into the hillside, screening it from neighborhood residents so that we continue to understand that the essential character of the neighborhood is not going to be substantially altered. The variance would not adversely affect delivery of governmental services, and we really, primarily going back to the property owner's predicament in locating this pool, cannot be obviated by placing it entirely within a rear yard, but that it has to be located within a portion of the front yard. I cite the CAGIS map that was provided that the pool be located no more than 10 feet into the front yard, where there was testimony by the applicant that it was more like 8 to 9, but the actual document we have here shows 10, that it does not encroach any more into the front yard any more than 10 feet. And at this point, that there is landscaping that would be included, but no additional decking structures would be included as a part of this variance, that whatever decking is to be utilized is already existing. Testimony from the applicant said that there would be landscaping, tall grasses behind it, landscaping in front of it. And again, installation within within a year and completed no longer than 2 years. And I'm sure they want it pretty soon.
A motion, do I have a second?
I'll second.
Further discussion on it? I'd like to just clarify one thing with that,
Yeah.
Steve, if you don't mind. I get, we're really saying that there'll be no decking that goes into the front yard area. I mean, I don't want to prevent them from doing whatever decking they think is appropriate in their rear yard area that would have otherwise been permitted.
Okay, all right.
But
Great clarification.
Any deck would have to be within the rear yard, or
Okay.
they'd be back here for another variance to have
Okay,
decking within the front yard.
so then I amend the motion to say that any additional decking that would be included in this project would also not encroach into the front yard. Thank you for that. That's a great second. Great addition.
Okay, we have a motion and a second. Betty?
Brian Miller.
Aye.
Jean Beckholz.
Aye.
Steve Hamer.
Aye.
Brian Johnson.
Nay.
Rick Oversmith.
Aye. Okay. Case number 16, 2013 BZA. The columns on Ayers Road and Riverview Estates.
Well, we heard the testimony that Mr. Shelley was okay with it. I do have concerns when you put a substantial masonry structure near the right-of-way, but Mr. Shelley's okay with it. He's the one that's going to have to deal with it with the snow plows. He's the one that's going to have to look at the, get it okay with the fire. And I'm sure Mr. Ferrugia is going to place it so you can have appropriate turning around it. And I did see that those utilities were in the way, so I think I would support it.
I do think we have Mr. Shelley's answer in writing attached to our, or at least in an email
Yes.
attached to our
An email.
materials.
I think the other thing that led me towards agreeing to grant the variance is that this is not going to be a high-traffic area. And it's a nice wide right-of-way now, and there is substantial between the back of the concrete curb and the blacktop pavement that's 28 feet wide, and it, as you get around into the bottom of the cul-de-sac, it does seem to get a little bit bigger. They're certainly not going to put something that's going to be in the way of snowplows and emergency vehicles, and they're going to be responsible, I'm assuming, for maintaining the balance of the driveway, the private drive. I'm typically one that never puts anything in the right-of-way. I'm never going to allow that. When he said yes, I was surprised. So, but once I looked at it more closely, because it is a wide right-of-way, and there's still room even from the back of curb to the right-of-way line that they could add sidewalks or whatever they wanted to do. I think there's plenty of room there. That's probably
And
the
I
design of
thought the
developer.
columns actually serve a very useful purpose. If that's a driveway that's going to ultimately serve up to 5 houses.
Right.
I think to identify that location is actually
Yeah.
a very helpful, and we certainly heard testimony that because of the utility boxes, there really isn't a great alternative.
Yeah, because it's not that intuitive that there's more lots back there.
Back there, I didn't, yeah.
You're right.
I'll make the comment that good luck with growing that landscaping along that cul-de-sac, because I love Anderson Township, and they clean our streets great, and I live on a cul-de-sac, and they pile that snow up right on the landscaping I have in the right of way. Good luck growing that.
Good point.
But I love when they're doing it. I'm not complaining.
Good point.
Well, when they show up at the end of the street, they'll just let you into the truck, and you can go ahead and plow it to your heart's content.
I'm thrilled, I'm not
Mr.
complaining.
Shelley would say you don't want to live at the end of the cul-de-sac.
Yeah.
That's where they
I'm
stack their
thrilled,
snow.
I'm thrilled that they're, got that much snow off the street. Steve or Brian, any different thoughts on that?
No.
Okay, entertain a motion on this one. Whose turn? Who wants to do this one?
Okay, well, I'm not very good at this, so I'll give it a shot.
Practice makes perfect.
In regarding case number 16, 2013, location of 7967 Ayers Road, I make a motion to grant the variance to allow a portion of 2 decorative columns to be located in the right-of-way where they're required to be outside of the right-of-way per section 17126, and that they be installed as part of the site plan that was submitted to the board. It's sheet number 1 of 1, file number 04-446. I don't know if these are marked as exhibits. The variance is not substantial. There is an approval from Mr. Richard Shelley, the Public Works Director. The character of the neighborhood would not be altered. Actually, it would probably enhance it a little bit, showing that it's an entrance to a private drive where 5 homes will be. I don't know if they're there now. The variance will not affect the delivery of government services. They did confirm that it will not, the fire emergency crews can get back there okay. And cannot be feasibly obviated due to the location of the utilities that are there, the underground utilities that are already there. And that the spirit of the zoning resolution will be observed, and substantial justice will be done by granting the variance. And that these be installed within a year, finished within 2. Started within a year and finished within 2.
Yes.
Yes? Okay.
I'll second that.
Motion and second, any further discussion? Betty, would you call the roll, please?
Brian Miller,
Aye.
Jeannie Bechtold,
Aye.
Steve Hagan,
Aye.
Brian Johnson,
Aye.
Rick Emerson.
Aye. Okay. Discussion of bylaws. I was going to say, without Fred, we just can't have it. Plus, you're going to get us back a revision.
Yeah, and Jerry and I have talked about reducing my number.
Right. So if you could get those to us before a meeting so that we have a chance to review, that would be grand. With that, we're going to take a brief recess and let staff go ahead and type up the resolutions in cases 14, 15, and 16. All right. Thank you.
Okay, so this one that's continued for next month, should we just hang on to this?
Yesterday, I saw Brian there. We went back down that private road, and there's 6 wild turkeys walking around.
beautiful site. It's beautiful. I saw. It's a beautiful location, I would say.
All right, we're going to come back from recess. Get your mics. Have it on the record. All right.
We're not going to do
We're not going to do 13.
13. We're not going to do it tonight, but staff's going to type it up for
Gary's review,
Gary's review next time.
and then formal action next time.
Okay.
14. Okay. In number one, where it says the existing setback of the home is 35.9, can we just move existing to the setback of the existing home?
That's a good point.
Thank you. And I think this is the one that I wanted to add, the property owner did not have knowledge of the,
Yes.
On that. Up back in the middle in number 2, says the primary location of the additions should be R onto the west side.
Or make
Down
it,
just a little bit more. There you go.
yeah, I got that too. Use space before number 5.
and maybe we can say after the property owner did not have knowledge of the zoning restrictions on the property, he believed his property extended further, believed his property extended further to the rear than a survey indicated. Something like that.
May I change your further to farther?
Hey, you gotta type what I meant, not what I said.
Is it variances or variance on the next sentence?
Okay. Everybody caught up? Roll it just to the bottom and make sure we got the signature blocks right. Okay, well, hold on a second. On 14, do we want to go ahead and act on 14? I have before you a final resolution on case 14. Do I hear a motion?
I move that we approve and journalize case 14-2013 BZA.
I'll second.
We have a motion and a second. Could you call the roll, please?
Brian Ellis,
Aye.
Jean Bechtold,
Aye.
Steve Haber,
Aye.
Brian Johnson,
Aye.
Rick Oversmith.
Aye. Okay. Fifteen. Excuse me.
Do we want to make that an above-ground pool? Clarify the accessory structure to be an above-ground pool?
Down on number one where it says in a portion of the front yard, I think it should probably say something like in a minimal portion of the front yard. And on number two, if you could add at the very end, and adjoining a busy roadway. You take out the AN and, yeah. Let's see, a second.
Maybe it's in just another sentence,
Yeah, I think
the,
it's
maybe
second
put
sentence
period
would be-
after residence and just
Yeah.
do the proposed location adjoins a busy roadway.
Yeah,
Or,
that sounds good.
I'll go back to that previous sentence. You put a caret in the end instead of a period. Thank you.
am I caught up?
Mhm.
Scroll down, please.
Oh, I like how you did number two.
I think the same comment that Brian had before, the variance is hereby granted.
for a motion.
Yeah, it's just scroll down just to the bottom. It finishes up okay. Yeah.
Mr. Chairman, I move in case 15-2013, the board approve and journalize as submitted.
Second.
Motion and a second to approve and journalize the resolution before us. Betty, could you please call the roll?
Brian Miller.
Aye.
Jamie Bexell.
Aye.
Steve Haver.
Aye.
Brian Johnson.
Aye.
Rick Springer.
Aye. All right, 16. 7967 Ayers. You're already fixing that one.
I just take the old one and copy it in.
Oh, I see, yeah. Any changes?
In number 3 at the end, where you say the proposed location will not impact the roadway, I think we're talking about impacting the delivery of services. 'Cause it's,
What did he say? Which, what did Shelley's email say?
he says, I don't feel as though they present a hazard.
Hazard. Well, we can say that. As verified, the proposed location will not pose a hazard,
Right.
present a hazard.
There you go.
Looks good.
Oop. Okay, cool. Probably the location of the, oh, I'm sorry, go back up again. There we go. Not negatively impact use of, okay, works.
Do we want to call it roadway or right-of-way? We're granting the variance for
Went
the
down.
right-of-way. Uh-huh.
Right away. Good catch. Any other changes?
Document, oh, the plot plan, you got it. Elevation drawings, okay. June 21st, 2013,
Oh, no.
okay, that's all right.
There was that one there. Yeah, June. I have June 20th.
On these, for this one?
It's the receive stamp over
Oh.
here.
Hey, it's we usually use as a receive stamp.
Okay, thank you. All right,
All right.
okay.
Mr. Chair, in the case number 16-2013 BZA, I move the board approve and journalize the variance request.
Second.
We have a motion by Mr. Haber, a second by Mr. Johnson. Any further discussion?
No, thank you.
Betty, could you please call the roll?
Brian Miller.
Aye.
Jamie Bexell.
Aye.
Steve Haver.
Aye.
Brian Johnson.
Aye.
Rick Oversmith.
Aye. There being no further business, meeting's adjourned.